Council, you don't have to unmute or start your cameras. This is the staff attorney just letting you know that thank you for showing up. I have not received any type of message from the judge about a delay, so I expect her to be on momentarily. Once you see her appear, just start your cameras and unmute and we'll get underway.
Thank you.
Thank you.
Good morning, everybody. Give me about 2 minutes and I'll be ready to get started, okay?
Thank
All
you.
right.
Thank you. Good morning. Sorry for that brief delay. I needed some more
Good morning.
coffee and nobody wants to talk to me without more coffee. So,
I understand.
I see.
but I do appreciate your patience. Good morning, Mr. Dominy and Ms. Gibson. I also
Morning, Judge.
appreciate y'all making time to sort of talk through these issues. Is there a delay on my end? I apologize if I'm not coming through clear.
You're fine.
Nope.
Okay,
You're
good. So where I think we are, so one, I am aware, Mr. Dominy, that you have now actually filed the planned petition to quiet title that you had referenced previously.
Yes, Judge.
I know it hasn't technically been accepted.
I had intended to try to file it in time to get a case number, but it just did not happen.
Yeah, I suspected.
Yeah, what I suggest is that the document that I forwarded to counsel and Mr. Freehoff is exactly the document that's going to be filed within a few days, presumably.
Okay.
So
Right.
I would suggest that we can look at the contents of this document to determine.
Right. And so just so we're both having the same conversation, because we use some of those terms a little differently. My understanding is that you had filed the document in the sense of it's been submitted to e-file or it's been submitted to the court's authority. It just has not made it into the court's docket because of the delays associated with our cyber attack.
That's correct. And I forwarded the filing receipts as well.
Right. That's the only reason I corrected you is because you said it hasn't been filed per se. And what you mean is it hasn't been accepted into the system.
Exactly.
Okay. Yeah. The only reason that I wanted to be specific on that issue is because I think I mentioned to the parties that part of what I wanted to discuss today, because of the delays that have been associated with the difficulties Ms. Gibson has had with, clients who I know one of your clients passed, et cetera. These family members all keep, it's a very fluid situation when you have this sort of extended family issues that seem to keep arising here. And so one of the things that we had discussed at our most recent hearing, given that this matter has been on the docket for a long time, it's been stayed, it's been unstayed, and Mr. Dominy had made the suggestion at the most recent hearing, and I think by communication to the court with a copy to Ms. Gibson, that he was planning on behalf of his client and has now done so to file a quiet title action. And I think that what would be helpful to me is to start with this. So I think I said during our last hearing when I said, let's set this on a separate day so we can sort of talk it out. I think I said, look, even if we were to spend all the time and sort through all of the issues presented by the current action that's pending, who has a claim, who doesn't have a claim, who's got an interest, whose interest has been defeated, whose interest has been waived or defaulted, that ultimately there would still end up having to be a quiet title action. Now, it might be a cleaner quiet title action because at that point, everybody would be clear on who had what interest and you could just go and file it pretty quickly, but it doesn't solve the problem of ultimately requiring that next step. And so one thing the court is considering is accepting Mr. Dominy's invitation to consolidate this matter into the quiet title action and hash out these issues there. And so, Ms. Gibson, I would be interested. I know that you already mentioned during the hearing, and that's usually the first concern I hear, is about cost associated with a special master. But what are your concerns if the court were to consider that approach?
Well, thank you, Your Honor, for giving us the opportunity to speak through these issues. Having dealt with this case for many years now, I do believe that this case is not as complicated as Mr. Dominy is presenting it to be. The issue in this case has been and always is the seminal issue is tender. JWM being a tax deed holder, they have to accept a tender of the funds that they paid, the statutory amount, and that would clear the tax deed. But their entire position has been to avoid accepting that amount. The initial case in 2015, decided by Judge Brasher, stated that although the closing attorney making an offer to pay the tender amount at closing was not a tender, that the family, Charlene West, the estate, and the estate of Oscar Frazier and Douglas Slapley, could tender the amount. Because
Right.
at that time, Mr. Dominique's position was that he did not have to send a letter to foreclose the right of redemption on Douglas Slappy. That the closing attorney's offer was not a tender, and therefore they were completely out of time. And Judge Brasher ruled that in 2015, that was not the case. They could tender. Responding to his order, we did tender, and that's our Exhibit N in the complaint that we filed. He walked the check back to my office and refused that tender. Then he filed an appeal. We cross-appealed, and the Court of Appeals ruled in 2017 that yes, we could tender. So I did it again, and that's Exhibit N. I sent him another check for the 2017 rate that included extra interest. And he walked it back to my office and said, Catherine, my barbershop is right here. So while I'm getting my hair cut, here's your check back. And he brought me back the tender the second time. So at this point, I think 8 years later, depending on which marker you want to use, he now is filing a quiet title action and saying that, oh, I sent them a letter stating that they should tender in 2023 at the 2023 rate. And because they did not pay us an extra $50,000 in interest, now I have the right to quiet title. So at this point, we believe, Your Honor, that the tender issue needs to be decided. If the court decides the tender issue in line with Judge Brasher and the Court of Appeals, and we tender, then all of those other issues are moot and they go away. Now, I think the quiet title action that he filed has problems because this is considered to be a plea and abatement because we already have
Before you, hang on, sorry, Ms. Gibson. I think there's a little bit of a delay, so you didn't know that I was trying to get your attention.
Okay.
Before you switch to that second topic, which it sounds like you're transitioning to, answer one question for me. So from your perspective, if the court were to rule in your favor on the issue of those two efforts at tender, right? What is the result of, if the court ruled in your favor that in fact you did tender, what is the result of this case?
Okay.
The one that's currently pending.
So if we tender, and then he rejects the tender wrongfully at that point, he has no claim on this quiet title action. He has no claim. The quiet title action, this new case, will completely go away because this new case is saying, I offered them to tender and they refused to tender. That's the opposite position that he's taken in both in previous cases. So this 2023 quiet action will go away completely because at that point we have tendered, we have paid JWM the $58,000 that they are entitled to, and then they will have no further claim. They are a creditor, so they are only entitled to money, and that's what we've tried to give them over these few years.
Okay. But to put a finer point on it, what I'm asking is, so I get that the quiet title action in your perspective would go away. Although I wonder, would your client still be in a position to need to quiet title? But I'm actually looking for a broader picture, right? So if I were to rule in your client's favor that in fact tender can still be made despite its rejection, or that in fact tender was made and it was rejected, right? So the ultimate result is the quiet title goes away, your clients redeem the property because they've tendered, and then who owns the property?
The property is owned by the estate. Within my complaint that I filed a quiet title as to JWM. That particular type of quiet title does not require a special master. The quiet title as to the world does
Right.
require a special master. I don't need a quiet title as to the world. The only quiet title action I need is as to the tax deed, which is conventional quiet title, and I don't need a special master to say that they tendered that amount and that the JWN tax deed is no longer valid and the property has been redeemed.
Okay, so that answers that question. I thank you for that. Because again, this is at least to my way of thinking, a factually complicated case. And I know that both of you want to tell me it's very simple from your perspective, but part of that is because y'all have been steeped in these facts for a long, long time. So I need y'all really and truly to explain it to me like I'm a fifth grader, okay?
Okay.
So and you did that just now. That was very helpful, Ms. Gibson. So I think we're starting to transition to a different topic, and please feel free to move on to that issue.
The second topic is about the probate issues in Charles West. And so that has been a red herring, I think, a rabbit hole that I even initially fell into. I'm guilty of it. But I do think after living with the case this long, Mr. Domini's done an excellent job of muddying the waters. And so this Charles West issue has been a red herring because both probate courts, DeKalb and Fulton, have said JWM Holdings does not have standing to object to who is appointed, and also they don't have standing on the estate issues because they are a creditor.
I don't doubt that necessarily, although I stay far away from probate issues when I can. I do question, though, why then, and maybe this is the rabbit hole you're talking about you fell down into, why then did we stay the case to figure out who the stakeholders were in the estate if, in fact, the result of my ruling in your favor, Ms. Gibson, would really leave that probate issue open? Because I think I understood you to say that if I ruled in your favor, then the title, the possessory and ownership rights of the property would revert to the estate. And so then the universe of people would still have to fight about who actually had an interest in the property. And my recollection is that those parties aren't getting along very well in terms of figuring out who owns what. Not that they're actively fighting, but that the initial passes at trying to agree about how to partition that interest or whatever else have been unsuccessful.
So the issues with the probate, the Charles West issue came up because he's the owner's son. He's Charlene West's son, and he was his interest was sort of raised in a will. So that is why Mr. Domini was able to inject him into the case and make his estate an issue. But the Judge Brasher and the Court of Appeals had already said that Charlene West and Oscar Frazier, who were the owners and occupants of the property, had the right to redeem the property. So did Douglas Slappy. So the right to redeem does not impact the whole probate issues. But I will just delve quickly into the probate issues, as I think that's why the case got stayed. Charles West issues came up because he had a different father on his birth certificate and his death certificate. And Mr. Domini kept saying to the probate court, he has all these relatives. She's not naming these relatives. He wouldn't tell us who these relatives are until recently he's filed an affidavit from a genealogist who has gone on Ancestry.com and relied on this website to find all of these potential people who could have possibly been related to Charles West. And so in DeKalb County, the judge there has said, just put an asterisk by these people and name them and put them on your petition, since he has filed this affidavit. He doesn't have standing, but since he's raised it and it's in the record now, just put an asterisk next to their names and put them on your petition. So we have done that, and we're going to be filing that with regard to Charles West. As to Doug Slappy, who just recently passed, unfortunately, the OCGA 91125, we do have to substitute in your case because he was a party. And we have 180 days to do so. We did meet with the family and we will be substituting. There's no conflict with regard to my clients and who owns what, but that's all going to be sorted out in the probate cases. The issues here have to do with tender, and that's the only issue before this court. And so Judge Brasher and the Court of Appeals have said that the parties that existed in the first case, which was Charlene West and her husband, Oscar Frazier, they could redeem the property. And that's the only issue that needs to be decided in your case.
Okay.
Or I would say that's the major issue to be decided in your case.
Okay. Thank you very much, Ms. Gibson. Mr. Dominy, what
Well,
say you, sir?
First of all, Ms. Gibson is picking out this one issue, the issue of tender, among a number of issues that are pending in the current case. Regarding the issue of tender, we've addressed it in this case in our motion for summary judgment. We made argument and we presented evidence as to why the rejection of those tenders was proper. Namely, they were materially deficient in amount. Ms. Gibson never responded to the motion. She filed something that she captioned a motion for restraining order recently with no evidence, no affidavits, no reference to discovery.
Now, one issue though, Mr. Dominy, in fairness, isn't the case technically currently stayed? Or was it stayed and then reopened?
No,
When was it reopened?
It was never reopened. The motion for summary judgment was filed before it was stayed.
Right, but.
And she had plenty of time to respond before the case was stayed. I'm trying to get the procedural posture understood and out on the table. So
I appreciate it, because normally I would have Odyssey open and be looking at the record while we were having this conversation. And I literally feel like I'm doing this with one hand tied behind my back, because I can't do that right now. So
Judge, I'm checking into it. I believe it was reopened within the past 6 weeks.
Well, I think the more pertinent question, though, would be, when was it stayed relative to the filing of the summary judgment motion?
The motion for summary judgment was filed on July 2nd of 2019, and the case was stayed on, the first order was entered on, well, there were two orders staying the case. One was entered on February 12th, 2020, but I think there was one before that. Oh, yes, there was. It was, Judge. Yeah. It was September 24, 2019. So the motion for summary judgment was filed July 2nd. The consent order stay in the case September 24th. Okay. So the purpose of the stay was your concern that you didn't have all the parties before you.
Right.
And based on Ms. Gibson's representation that her client, Ms. Annette Lowe Strong, had filed a petition for letters of administration in the DeKalb probate court, Your Honor stayed the case. But before I get to allow her time to get appointed, but before I get into that, regarding the tender issue, Judge, we have no compunction going, asking Your Honor to go forward with a ruling on that case, but it's not the only issue. And the question is, as a matter of fairness to the parties and as a matter of judicial economy, how do we want to approach this? Certainly, the issue of the tender is one of many issues. It is one that the special master could determine along with all of the other issues. Regarding the probate case, the reason for the delay is that Ms. Gibson and her client, Annette Lowe Strong, have, and there's no way to sugarcoat this, they have falsely represented to this court and to the probate court that Charles Lawrence West's sole heir at law was Douglas Slappy. Well, that is patently untrue because Slappy was Charles Lawrence West's first cousin. Slappy has 7 brothers and sisters, slew of nieces and nephews. If he is an heir, they are heirs. And by the way, we have his deposition testimony in the prior case, the 2014 case, which Judge Markle, your predecessor in this case, entered an order stating, it's probably the law anyway, but just to clarify, he said, this is put everybody on notice. I'm taking judicial notice of everything in the 2014 case. His deposition testimony, Slappy's deposition testimony, testifies as to all these other heirs. That was our concern. We had a mediation in the probate court in 2020, and we reached a mediated agreement where my client, JWM, agreed to withdraw its caveat if Ms. Gibson would amend her petition and add the brothers and sisters, add the heirs. Well, she never did that. Instead, last year, she filed an amended petition and an heirship worksheet that doubled down on this falsehood that Douglas Slappy was a sole heir. We did hire a genealogist. We didn't need a genealogist to tell us who the brothers and sisters were, although it helped. And we renewed our objection based on the affidavit. We had a status hearing before Judge Hargrove, DeKalb County Probate Court, in November. I want to say November 21st, in which she looked at Ms. Gibson and said, did he have brothers and sisters? And she finally, for the first time, admitted it. And Judge Hargrove said, amend your petition and add them. Now, that was in November. I checked the docket yesterday in the DeKalb Probate Court. Ms. Gibson has found nothing. So all of the delay for the last 3.5 years has been due to Ms. Gibson's and her clients' false representation that Doug Slappy was the sole heir. It is our position that Annette Lowe and Douglas Slappy are colluding to the exclusion of the other heirs. And in connection with that, Ms. Strong issued an administrator's deed, supposedly conveying a half interest in the estate property, the piece of property that we're dealing with, and is claiming an undivided 1/2 interest in the property based on that deed. We have filed a claim, in this case, our counterclaim, to set aside the deed because she had no authority. She's the temporary administrator. So this case, the pending case before your Honor, it can't go forward because Slappy is a necessary party. Both parties to the deed are necessary parties, and what 9/11/25 says, that's the substitution of parties.
I'm familiar with 9/11/25. Yeah.
Right. It says that if the action can proceed among the remaining parties, go ahead. But if it can't, the thing is abated. Well, this action can't because Slappy is deceased. This action cannot go forward because there's no personal representative for the estate of Charles Lawrence West. He really is the principal character in our cast of characters because he's the sole devisee under his mother's will. The fact that Slappy is dead, that doesn't impact the quiet title action at all. It impacts this action. The fact that Ms. Gibson has not, after 3.5 years, gotten her client appointed as Charles Lawrence West representative has no impact on the quiet title action. It prevents this action from going forward, but it doesn't prevent the quiet title action from going forward. So
let me ask you, other than what you've just identified, which is that there would be, that I think I understand your position to be that this case, because of my expressed concern consistently over the years about whether or not the proper parties are in front of me, the universe of parties who might have an interest, et cetera. Isn't that the same? I think I understand your position that because of that, this case, this in personam case, couldn't go forward, but that an in rem quiet title action could go forward.
That's right.
But don't you have the same issues, right? I mean, don't you still have in the process of determining a quiet title as to the whole world, the burden on a special master to figure out whose heirs are whose and where the lines go and who is entitled to an interest or not? Particularly if, I mean, I understand your position is that the redemption was never accomplished, and so your client is the holder of the interest. But wouldn't a special master have the same issue of having to resolve that issue? And if it were resolved unfavorably to your client, be stuck having to resolve the same issues Ms. Gibson's complaining about, which is if the property belongs to her client, who does it belong to? If it was properly redeemed, right, then there's this mess of heirs. Isn't the special master going to be stuck with the same mess that you're concerned the court is stuck with in this case?
Yes, but special master is appointed specifically for that purpose. All right, and we have already, Judge, my client has already untied all of this stuff. We've already hired the genealogist. We've already done all the work. It's been a tremendous amount of work. All the work that Ms. Gibson should have done, we've done. We've identified all of these parties. We have set out clearly, if you look at Exhibit G in the petition, who these people are and where they fit in the heirship, in the succession of title under the laws of intestate succession. The question is, does the court want to get into that, or should a special master handle it? Is a superior court judge going to want to sort through 90-something potential parties in personam to determine who the right parties are, or should a special master do it? Judge, that's why we have these kinds of statutes. That's why we have special masters. That's why we have special statutory proceedings, so that qualified professionals, namely attorneys in this case, can put the time and focus necessary, because they're getting paid. They're putting the time and the focus necessary to untie these issues. I doubt very seriously that it would be an efficient use of the court's time to have to spend so much time on these complex heirship issues just to get the people in front of the court, all of whom would be in personam parties. Is that practical? That's the point. It's not practical for you to try to do this. It's not practical to try to do it in an in personam action. An in rem action.
Let me ask you a question, Mr. Dominy. So I don't necessarily disagree with you that that's not necessarily a valuable use of the court's time, or that the court would be, as Superior Court judges, we are often asked to do things that, to rule in issues where we have to learn, right? Be educated by the lawyers. But of course, the special master, there's a reason we have special masters, particularly in the area of real estate title and property interests. But one question to Ms. Gibson's point is, if the court were to take up and resolve, again, potentially the issue of the redemption, the tender, right? Does that obviate the need, depending on how the court rules in one way or the other, for a special master? For example, if I were to grant your summary judgment and say, yep, they never redeemed, then does JWM need a quiet title?
Yes.
Okay, but the quiet title would be basically, there was a right of redemption, but it was never exercised. Therefore, we own the property and all these other interests are canceled, correct?
Correct. Look, let me say,
Okay.
we don't have
I'm
any
sorry, you broke up,
objection.
Mr. Dominy. Say that again. I heard look.
Okay, can you hear me? Um, we
I can, yes, sir.
we don't have any. We don't necessarily think it's the best way to do it, but we don't have any objections. If your honor wants to decide that issue, we can decide that issue. You can decide that issue.
Well, and
we don't have
the
an
flip
objection to
side,
that.
right? But the flip side of that question is, because Ms. Gibson has said the real issue here, the main issue here is this issue of tender, right? If tender was appropriately accomplished, then the fact that it was rejected, right, wrong. If it was appropriately done, then the rejection of it would be wrongful. And if the court were to rule in that direction, right? So your summary judgment is that tender was never appropriately made in the right amount, and therefore there's been no redemption,
Right.
Which would basically leave your client as the only one with an interest. I mean, there might be resulting interest, but you guys would be at the top of the pile.
Well, we would be the tax deed holder subject to having to clear our title. So we would have, if you ruled that there was no redemption, we'll have to do all the quiet title anyway.
Right. And so my next question is, what happens if I rule that there was a redemption that was wrongly rejected? What happens if I were to rule in that direction in this in personam case? Procedurally, what would happen next?
They would own the property.
And your interest would be fully defeated, and then it would be, so in other words, if I rule on that issue, right? If I rule on that issue, then either of the parties are going to have to go quiet title.
We certainly would, whether you see, Ms. Gibson,
I understand they might not, but ideally they would have a mess of interests that they might also need to seek special seek a quiet title.
Well, when a property is redeemed, it goes back to the date of the tax sale.
Okay.
It's just restored to the date of the tax sale. In this case,
so then it would be the probate court mess, not a special master quiet title mess.
It would be presumably vested in the estate of the deceased record owner, a woman named Charlene.
Right, and then the probate court would have to figure out whose interests were whose.
Well, they could probably sell the property at that point. They'd probably have good title. The estate would, but however, see, in the 2014 case, Annette Lowe Strong actually sued Doug Slappy. Doug Slappy actually sued Doug Slappy, and Oscar Frazier, well, I don't know if you want to get into all of that.
I remember there were some colorful disagreements. Right.
Right. Ms. Strong represents Annette Lowe Strong as administrator of the estate of Charlene West Frazier and administrator of the estate of Oscar Frazier, and they have competing claims. That if one is right, the other is wrong. But that's their problem. She's right. If we're tendered the redemption price, then we have to quit claiming the property. That's the way that works. And the title gets restored back to the tax deed day, and it's not our problem anymore.
Okay.
So the question is whether your honor would want to just go forward with that one issue in a situation where we could not go forward with our claims, to pick out this one claim and decide it in a scenario where we are not in the position to assert any of our claims because of Mr. Slappy's death. I don't know. And I don't know if your honor is going to be comfortable entering an order without a personal representative of Charles Lawrence West estate. That was the whole purpose of the stay.
Well, and I will say this, whatever I do, if I carve out an interest, I mean, we still have to have a conversation about whether or not the proper parties are before the court, but not for the least of the obvious reasons that Mr. Slappy is now deceased, and he is currently a party, and he is now deceased, and will need to be substituted.
Judge, I mean, from our perspective, the only really two viable, from our perspective, the only two viable alternatives would be for you to consolidate the quiet title action with this action and let everything be heard by the special master, or since the tender issue would be dispositive, perhaps you could just decide that issue.
But here's the question. So I'm sure from your perspective, there is a universe of undisputed facts that would direct in favor of the court ruling in your favor on the issue of the lack of proper redemption, right? A lack of a tender,
Right.
therefore resulting in the property not being redeemed.
Right.
Obviously, whether Ms. Gibson has filed a response to that summary judgment motion or not, because the Georgia law says we don't grant summary adjudication by default, right?
That's right.
The
That's
court
right.
would
She
have
can
to
file
look at the,
affidavits before the day of the hearing.
right, we
For
have to
instance.
look at the substance, and that's really my question. If it is not a matter of undisputed fact, right? What does that trial look like? I mean, don't we, because that's really what the whole reason this case got back on my agenda was. This case is forever old and it needs to be tried. It needs to be moved forward toward resolution. And so one of the concerns is there are so many tangential issues that if the court doesn't rule on it at summary judgment, I mean, the only possible outcomes of summary judgment are either your client is right, there's undisputed fact that demonstrates as a matter of law that Ms. Strong can't recover because she didn't properly redeem, right? That's one result. That's grant your summary judgment. And the result of the summary judgment is there was no tender, therefore there was no redemption. Is that not right?
That's right, but that doesn't necessarily mean that she lost the right to redeem. So it doesn't mean we win the case.
Well, Your Honor, I think that the issue that needs to be decided in terms of the summary judgment, like he is stating, is the amount. We utilize the amounts based on the judgments of the court. So in 2015.
Right. No, I understand that, but my point is, if the amount was insufficient, then I believe the law says if the amount was insufficient, there wasn't a proper tender, and that's essentially what Mr. Dominy is arguing. And if there's not a proper tender, then there was no redemption.
That's right.
Right. I'm not saying that's the answer. I'm saying that's one possible outcome.
Right.
Yes.
It would just be what date would the tender have been tied to?
Right. And if I deny, but here's what I'm trying to get to in terms of procedurally, what would this court, if it declines Mr. Dominy's invitation to consolidate it with a special master, I'm trying to figure out what it looks like for this court to do. And so if I were to deny Mr. Dominy's summary judgment motion, it would only be saying that there are disputes of fact that the court needs to resolve about the timing of the tender and the amount of the tender and whether it successfully accomplished a redemption.
Judge, I don't think any of those facts are going to be disputed.
I understand. I'm not saying that I would rule that way, but what I'm saying is,
but
if I deny your summary judgment motion, the only result of it is there are disputed facts that the court needs to hear evidence on, right? And so then we have a trial, but the minute we have a trial, we are going down a rabbit hole of all these tangential issues, and not just let's have an evidentiary hearing on the timing, date, and amount of the tender.
That's absolutely correct. That's absolutely correct. And I would also point out that the gist of the quiet title action is our notice of foreclosure of the right to redeem in November. So this is a new cause of action. It is not a part of this case. But here's the point. The foreclosure of the right to redeem eliminates all of the other issues in this case. So for the court to go forward adjudicating these legal issues, the redemption, the validity of the administrator's deed, the validity of the tax sale, these these issues have been resolved, in our view, by the failure of the failure of any party to tender the redemption amount in November. So how would the court handle that? It would seem to be a huge waste of time. Now, the court could take cognizance of the foreclosure of the right to redeem. In that regard, we think we would have to file a motion for supplemental pleading. I mean, these causes of action arose, years after our counterclaim was filed, and we considered doing that. We considered filing a motion to file a supplemental pleading based on the foreclosure of the right to redeem, but we decided to file a new action.
Your Honor,
Okay, hang on. And that's actually why, yes, you may for just a moment, Ms. Gibson, and then I have a couple more questions that I'm going to direct to both of you, just briefly, because like I said, you guys are so into the facts, and I'm trying to stay up here because a lot of those facts aren't relevant to what I'm deciding to do substantively. Go ahead, Ms. Gibson.
I think Mr. Dominy is once again complicating the case unnecessarily. We could file, and I've done this for Judge Cox before, we could file a document that just says these are the legal issues that need to be decided by the court. Something that narrows the issues, because I don't think that there's so many tangential issues in the initial case. The issue is about tender. I don't know how many other claims a tax deed creditor could have against a property owner. But again, he's trying to make it seem like it's so complicated, the court wouldn't want to touch it. And it's not that complicated. If we can get through the issue of tender, and we can get through whatever issues the creditor would have against this family, then that quiet title action goes away, in my opinion, because they do not have a claim to the property at that point. And I think that we've been, and it's my fault too, because I think that we have been so buying into this issue that these issues are so complicated, when really it's just a matter of, we tried to give you a check and you refused it twice. And now in 2023, you're saying that you want the check. And because we didn't give you the check in 2023, you're entitled to quiet title on this. He's
okay,
taking
so here,
positions.
Right, I understand. So here's my next question. One other consideration, which I think I already mentioned, is the issue of cost that is associated with the special master. And one question I have is, what do we expect the costs might be? And how would they be paid?
Well, one doesn't know in advance exactly what the special master's fees are going to be, but I can tell you this, it's my client that's going to pay them, not hers. My client will pay the special master's fee because, I don't want to seem cocksure here, but I think we're going to come out with title to the property, and there would be a lien on the property if we don't pay. We will pay the special master's fees.
The fees have to be split by the parties.
Well, that's why I asked, because statutorily I am aware that the statute requires, or it doesn't require, it provides for the parties to share the cost of the special master. And so one of the reasons I asked Mr. Dominy is that I have in the past, when I thought there were an unequal set of resources in the parties, right? A corporate entity with individuals, looked to the corporate party to be willing to take on the costs, so as because one of the issues I'm always concerned about with a special master is that claimants with limited means would lose their rights or ability to defend themselves or to explicate their interest.
That's right. Actually, what the statute says is the special master apportions costs, but it is never really entered our mind that we're not going to pay the costs, and we would be willing to we would be willing to have that put, for instance, in the order appointing special master.
Okay.
The special costs are going to way exceed probably $15,000 if we get into the 2024 quiet title action, which we believe that the 2017 case is dispositive of. In addition to that, we've already had two favorable outcomes in previously with this litigation. So we
Well,
believe.
I understand that. And again, I don't want to get into the weeds of that, but my understanding of what those favorable outcomes were is that historically JWM took the position that there was no right of redemption, and the court where you've had successful outcomes has said, yes, there is a right, you must exercise it. You can still exercise it. And I believe I understand the position now to be, your position is, okay, we were told we could exercise it, and so we tried, and it was rejected. But I also understand JWM's position to be, no, they never properly exercised their tender right that they had. And now, because there was no redemption, we've entered a foreclosure of the right of redemption because it's never happened.
Right. And by the way, Judge, that 2014 case, and you can read the Court of Appeals opinion. I don't know how.
I have, but it was a long time ago. So.
Okay, yeah. But Ms. Gibson's case was dismissed by Judge Brasher, the 2014 case, for failure to make a bona fide offer of tender before filing the suit. It was dismissed on those grounds. So I don't know how successful they've been. Also, the court did not rule that Ms. Gibson's client has a right to redeem. What they said was, we can't determine that right now, because our argument was under the case law that dismissal of that case prevented them from, it was res judicata. Under the case law, it was res judicata. The appeals court said, well, you can't ask the judge to render a determination of whether it's going to be res judicata in a second suit that hadn't been filed yet. So and we have asserted in the pending case, in addition to the insufficiency of the amount, the fact that they were barred, that they did not have the right to redeem. So all of those issues are pending before Your Honor in this case. And the question is Your Honor going to decide them? And if so, under what procedural context? Or are we just going to move the whole thing over to a quiet title action?
So one other issue that is associated, so you have repeatedly requested that the court consolidate the cases, right? And technically,
Yes.
as I understand the law, the court doesn't have the authority to actually consolidate cases absent consent of the parties. So if I were to rule in your favor and say, I think this matter is best handled in the special master, what would essentially happen is this case would be stayed.
That's
right. While the quiet title matter goes forward, and then presumably with the idea that the resolution of the interests by the special master with a proposed order that would come to the court saying, I've determined the following, would then be dispositive of the outcome of this action.
Absolutely. Exactly.
That couldn't be the case, because the special master there has to be a ruling in this case on tender before the special master could consider that issue. The issue in the 2024 quiet title action that he's filed is the right to foreclose the redemption that he sent in November of 2023.
I understand that, Miss Gibson, but if the special master, so he has filed a foreclosure of the right of redemption on the basis that the property's never been redeemed, and therefore he's entitled to foreclose that right. And if the special master, in order to decide that issue, the special master would necessarily have to also determine whether or not your efforts at tender that were rejected were in fact valid exercises of the right of redemption that were wrongly rejected by the creditor. And if the special master were to determine that one or both of those efforts at tender were proper and therefore wrongly rejected by JWM, then that would also inform the nature of the quiet title, because one of the reasons that we have quiet title, yes, it is typically brought by the party who believes they will end up with the interest at the end. The reason we require all interested parties to be before the court is because the purpose of the outcome of that is, just because JWM is the plaintiff in a quiet title action doesn't mean that JWN ends with a quieted title at the end of the litigation. That's why the law requires that all interested parties be present, so that theoretically the special master could determine that Annette Lowe Strong was the proper interest holder and properly attempted to tender, and it was wrongly rejected, and therefore Annette Lowe Strong is the holder of that interest, and it would then be quieted as to the whole world as well.
Exactly.
I understand, Ms. Gibson, that this is not it's not necessarily something that you want on behalf of your clients. But the primary concern that I had, regardless of how simple or complicated it might be, is that I think the quiet title action is the way to go. And the primary concern the court had was that it was, no offense to Mr. Dominy, but being used as a strategic pressure point because of the costs associated. I understand. Let me finish. That was a concern that I had, but Mr. Dominy has allayed those concerns by representing to the court that his client has consistently understood that they would need to pay the costs of the special master. And so I don't think is an effort to unduly burden claimants of limited means, which his client is not one, but your clients probably are. And I don't mean limited means, they probably have plenty, but you know, plopping down 15 grand on a special master is a lot of money. And so I think that my inclination would be to accept Mr. Dominy's invitation to appoint a special master in the quiet title action. That the order appointing the special master would include a requirement that Mr. Dominy's client pay the costs. And that this in personam action would be stayed pending the outcome of the special master's resolution of the title interests. That would be what I would be inclined to do. And I would also be inclined to ask the special master to do everything in her power to expedite, because this case has been going on for such a long time, that as I said, part of the reason it's on my radar again is to move this case forward to resolution. I think you, Ms. Gibson, are still going to have to deal with the issue of Mr. Slappy, but maybe those things become less of a primary need if we are dealing with a quiet title action where we're focused on the property and the various interests, than on who is who in front of this case. I also believe that the special master would be authorized to determine, as I said, necessarily would have to determine in deciding whether there was a foreclosure of the right to redeem. They would necessarily have to address the issues of whether the tenders that your client made, the 2 attempted tenders that were rejected.
That's right. And
were
that's
proper tenders
in the petition, by
right,
the way.
were proper tenders that were wrongly rejected.
Well,
Yes.
One of the issues is that right now with Mr. Slappy having passed and there being a suggestion of death, that no order of the court would be effective on him until we were allowed the 180 days to substitute. In other words, if the court entered an order,
I'm not sure I'm not sure that's right. I think that statutorily you're allowed as many as 6 months to substitute a party, but that simply, a failure to do so simply runs the risk of foreclosing that party's right in this case, or the right to vindicate that interest. I don't believe that it works in the reverse, that it prohibits the court from taking action, because if a party is deceased, then it's just a matter of procedure for the party to substitute a proper party. And I don't believe that any stay that the court would enter would limit the ability of Mr. Slappy's estate or someone on his behalf of asserting that interest. Presumably, not only in this case, but also Mr. Slappy, if in fact there is a putative interest, right? Mr. Slappy should be named as a party, or his estate or heirs of would be named as a party in the quiet title action as well.
Of course.
I can send the court case law, but if a party passes away.
No, I mean, if there's case law that says differently, please let me know. But as I said, I've always understood it to be an outer limit that applies to the party and not necessarily a limitation on the court's ability to take action. Now, I'm also not, I wouldn't presume that I could dispositively adjudicate a deceased party's rights within that time frame. But making procedural decisions about things that we're going to do, particularly, Ms. Gibson, when that party has counsel who it's merely a matter of time for them to find the right party in interest that will substitute in. I will, if you have case law, please share it with me and I will take a look at it. But I at this point don't think it limits my ability to allow the quiet title action to go forward and to stay this case pending a resolution of the issues in the quiet title action, because neither of those things would be dispositive of the interest of Mr. Slappy or his estate or his heirs.
Okay, I'll send you the case law. I think the case is just stayed until he is substituted in as a party, and that
Okay.
any order issued by the court is of no effect, because he's not a party who is deceased is not a party, and so the case is just stayed until he gets representation of an estate in the case.
Right.
Judge, I think the court is authorized to make administrative decisions.
Well, regardless, let me say this. I'm not actually ruling on anything in this case other than whether to stay it or not. And your position is that Mr. Slappy's being deceased functions as a stay. What I am ruling on is the allowance of the quiet title action to go forward and deferring this case to that quiet title action. Now, when 180 days gets here and Mr. Slappy, someone has been appointed, or, you know, a substitution has been filed to substitute in the proper party in interest, then the case would become unstayed. If the case law you're referring to is, again, I'm not familiar with it, but I don't doubt if you're characterizing that that's what the case law says. Then when that happens, the case would be unstayed and the court would simply go back to the case and say, I'm staying it while the quiet title action is going on. And so I believe I can do that, but I would still very much be interested in seeing that case law, Ms. Gibson.
Okay.
So in any event, I think what I am going to do currently, in the interest of managing my docket, take no action in the Annette, Lowe, Strong in personam case that is currently before the court. The in rem case, when it reaches the court's desk, the petition for quiet title would likely be granted, as I've said, although I would await an opportunity for any concerns about the specific nature of the petition, if there are any, in terms of the actual order that would appoint a special master. The next question, I can think there is a special master I frequently use Oh my Lord, my brain has just completely gone blank. Mr. Freehoff,
Yes, Judge.
the special master, Carolina Bryant.
Carolina Bryant.
Yes.
Judge,
Yes, sir.
Caroline is great, but we have a relationship with her firm.
Okay, well then we can't appoint her.
But may I say on this
We do
issue?
too. We do too. I mean, everybody uses
I
her.
sent,
Everybody uses their firm, so I don't mind using her. I've used her on a lot of quiet title
well, we don't
actions.
mind using her
And
either.
I've
She would be
used
Well,
great.
her-
Hang on. Yeah, I feel like this is a conversation y'all can have offline.
Okay.
I only mention Ms. Bryant because she is someone I use. She is this court, me personally, routinely appoint her as special master. She is routinely requested, but I also independently frequently appoint her. I don't have to appoint her. Oftentimes when people file petitions for appointment of a special master, they come with a request to appoint a particular person, and that's fine too. I simply mention that absent a request or some concern about who has been requested or a dispute about who is requested, the court would likely consider appointing Ms. Bryant. So the parties should consider if there is an agreement to go forward with Ms. Bryant. Or Mr. Dominy, did you request a particular person in your petition?
What I did, Judge, I tried to research your orders to see how you approached appointing special masters, but with the problems, I didn't get anywhere on that. And I put this in a message to Mr. Freehoff, and I copied Ms. Gibson. What I did is I took the liberty of contacting 3 very reputable, experienced Fulton County resident attorneys who handle quiet title actions: Monica Gilroy, Teresa Bailey, and Eric Tusing. I have no relationship with any of these people, but I did contact them to ask if they were available, and I sent them copies of the possible adverse claimants to do a conflict check. All
Okay.
3 of those reported back, no conflict, we can handle it. So
Okay.
our offer to the court is, here are 3 people. If you're inclined, you can choose from them. Caroline Bryant is fine with me. I don't know her personally, but my client's manager and I were discussing, we would love to have her appointed, but if Ms. Gibson agrees, it's fine. She would do a good, fair job. I'm just saying, in full disclosure, that I'm a good friends with members of her firm, and we do business a lot. Not her, but members of her firm. She would be fine. I just want to disclose.
I would be more concerned about a business relationship between your client and that firm. Separate, but separately, I only mentioned her because in the absence of any request, that's who I would probably go to. But the other individuals that you've asserted, I also know to be highly reputable. And so if that's the suggestion that's pending, what I would suggest is, why don't you and Mr. Dominy, why don't you and Ms. Gibson discuss if there's someone you can agree on. And if you can agree, great, I'll appoint that person. If you can't agree, then I will choose an appropriate person that will probably come from that list. But that's, I think, where we're going to leave it today.
Yes.
Which
I would
is,
just like to say, if I may,
yes,
very
sir.
briefly, that it's always important, right, that a good special master is important. But in this case, because of the complexity, I think we really need somebody that knows what they're doing, not an inexperienced special master. And so that's Caroline Bryant. Any of these 3 would be fine. So.
Okay. Ms. Gibson, I understand that I feel like the quiet title action is going to, I mean, the quiet title action was always going to go forward. I mean, it's not as if it's one or the other. I think the answer, though, is that it would be the court's preference to defer the issues presented by the in personam case to the quiet title in rem case. And so I think that's what I'm going to do.
All right.
And
But Judge, I think that when we started off, the issue was if the tender is proper, then that case does not have to go forward. It seems like we are going to
I don't agree. That was actually one of my considerations, is that if the tender wasn't proper, right, then Mr. Dominy has represented that he would then have to take that and go to the quiet title action and attempt to quiet the title as to the whole world, based in part on the fact that there had been a proper right of redemption and no exercise, right? There'd been a proper foreclosure, I'm sorry, of the right to redeem because there wasn't a proper exercise. And
if the tender was proper,
if the tender was proper, then your client would hold an estate title that would have to be sorted out by the Court of Appeals.
Exactly.
Excuse me, the probate court. Too many courts.
At least three. We got at least.
not really. I mean, that it wouldn't be the title wouldn't be sorted out.
Right.
The estate issues would be dealt with, but not
But
the
I
title.
guess my point is this. Somebody has to hear and decide the redemption and tender issues. And having a special master who has specialized knowledge and understanding of these types of issues, which the court lacks, seems to me like a better way to resolve this, when it also has the added benefit of resolving all outstanding issues. And I'm not certain that I'm not certain that the court has the ability to just try this case on that one issue, that in fact it would open the door to having to resolve all of the potentially outstanding issues, which I understand that you think it is a much more clear-cut case than Mr. Dominy is attempting to make it. But I still think it is slightly more. It's probably, the level of complexity is probably somewhere in the middle of what the two of you are characterizing. And ultimately, a special master is in a better position to deal with those issues. And the two concerns the court had is, one, you had raised, Ms. Gibson, that this was an effort at delay by JWM. And I don't think that there would be a significant delay occasioned by the appointment of the special master, particularly if the court requests that it operate as quickly as possible, which I will. I intend to, whatever order I enter, appointing a special master, to give them a heads up that I expect this to be handled in as expedient a manner as possible. And the second concern I had was about the potentially prohibitive or burdensome cost to your client or clients. And those two issues have been addressed to the court's satisfaction. And so I think that the better way to go here is to continue the stay of this case, and expedite the moving forward of the quiet title action. And you guys can argue about the tender and whether it was wrongly rejected or whether it was an improper, insufficient valued tender. And we will all go from there.
Right.
My goal is to, and the special master, I'm probably going to have to call and make sure that it's doable if I appoint them. But what I'm probably going to ask them to do is to endeavor to expedite this matter to the tune of about 4 months, maybe 6 if they really tell me that 4 months is not possible, so that this matter could be put to bed before the end of 2024.
Wonderful.
And that's going to be how we're going to proceed.
Right.
So that is what we will do. I really appreciate everyone's time and helping me talk through these issues. And I will look for email traffic from you guys letting me know if y'all agree on or wish to recommend one of a particular special master, regardless of it, whoever is listed in Mr. Dominy's petition. Just note that whoever you recommend, I'm going to have to call them and make sure that the expedited timeline that I want from them is doable, so that I'm not unduly burdening them with something that they can't accommodate in their practice. So
Good. So the next
Okay.
thing is Ms. Gibson and I will confer about hopefully agreeing on a special master. I will forward the filed petition and related documents to Mr. Freehoff when they're entered, along with a proposed order appointing special master.
Yes.
Very good.
Ms. Gibson, I understand that you disagree with my ruling here today, but is there anything else that you want to bring to the court's attention on this issue, or that that we've not discussed that you think the court should be aware of relative to the appointing of the special master or anything like that?
Yeah, I'll send you the case law.
Yes, ma'am.
Which I just wouldn't want it to be an appealable issue later on if an order was entered that had no effect while Mr. Swappy's estate had not been substituted. So I'll
Okay.
send you the case law to review that. And also I will also do some research on special masters as well. I just remembered that I think I have a case opposing Carolina currently pending within a state.
Well,
but
it's such a tiny
her.
universe, right?
Yes.
I mean, there's probably 20 that are routinely relied on by the courts in Fulton County. And so at some point it turns into this, 2 degrees of separation issue. So,
Right. I speak to her on my cases because she handles my quiet title actions as special master. And then I also oppose her in certain cases as well because
right.
we all do the same real estate litigation. So I will also do some research on potential special masters as well and speak with Mr. Domini to
Okay.
proceed.
Thank you both very much, and
Thank
have a
you.
good weekend. And